Let me see, we're gonna check for a quorum real fast. Codes committee members, 1, 2, 3. So got half, we got a quorum. What about you? You counts for 2? Oh, yeah, 2 committees. You got a quorum? So you good? Okay. Good evening, ladies and gentlemen. I'm going to call the Codes Convention and Tourism Committee to order. Council Lady, Chair Lady Van Reese and I have been tasked with conducting this joint meeting. Okay, Council Lady Van Reese, you want to make a statement?
Committee that attended, understand that the Roberts will need to recuse herself from voting, but I appreciate your presence in order to get a quorum, so thank you very much.
Okay, having said that, ladies and gentlemen, on the Codes Committee, we have 4 items before us. We have 3 that we'll share with tourism and convention. So we'll get started with the first 3 that pertain to both of us. The first item up is Bill 2016-375. Sponsors are Mendez, Sledge, and O'Connell. The caption read amends the Metro Code pertaining to the maximum occupancy of short-term rental property. Is there a motion? Second. Discussion. Councilman Mendez, I think you're the only one, and Councilman O'Connell, you have the floor. One second. Where is Mendez? Oh, okay. Sorry about that. Sorry about that, Bob.
No worries. Thank you, Mr. Chair, Madam Chair. So with the mayor having announced that the city will hire a consultant to look at how enforcement works on short-term rentals, among other things, I would like to move to defer this bill 375 indefinitely so we can have a chance to see what happens with the consultant's report.
Okay, members. Okay, there's been a second on the motion to defer indefinitely, Madam Chair.
Is there a motion to second?
Let the record indicate the Codes Committee voted 4-0 to defer Bill 375 indefinitely at the request of the sponsor.
And the record should show as well that the Conventions, Tourism, and Public Facilities Committee voted 4 in favor, 0 against, with 1 not voting.
Thanks, chairs.
Thank you, Chairman. Councilman at Large Mendez, thank you, sir. Councilman Sledge, I'm sorry. Okay, coming back around.
I am for the deferral,
Microphone.
No, it was Councilmember Roberts that's on record for not voting. Thank you.
Okay, sorry about that, Councilman Sledge. A little slow on the trigger. Okay, the next item we have up is a substitute bill, number 2016-381, sponsors Allen and Mendez. The caption read, amend the Metro Code pertaining to short-term rental property. Allen and Mendez are the sponsors. Is there a motion?
Motion? Second?
All right.
All right.
All right, discussion. Council Lady Allen. 1 second here. There you go.
Thank you, Mr. Chair. Just a reminder, when we had these 3 bills coming through, the reason there's a substitute on this one is we took some things that were duplicated in Bill 382, and then also sort of put what we considered to be the relatively non-controversial pieces into Bill 381, and sort of left the other 2 bills to be dealt with in an appropriate fashion at the appropriate time. So what Bill 381 does, I feel like are things that won't necessarily fall underneath the purview of codes enforcement as much as getting the permit application process and the renewal process right in the first place. So that being said, I don't feel like this one needs to wait on the consultants information about codes enforcement, and I'll just go through the 9 things that it does, and then we'll listen to the opinion of the 2 committees, because I'd like to hear what y'all think as well. First of all, it changes the permit application process to not be indefinitely open as it currently is. A permit that is begun but not followed through on will expire after 60 days. That was a request by the Codes Committee because they have a number of them that are just kind of hanging there and they're not sure what to do with them. But that gives, an applicant 60 days to get the information they need. So that's a housekeeping one as much as anything. The second one is requiring property owners to notify their neighbors by mail that they're intending to use their property as a short-term rental. This was a request by a number of residents who live next door to these, just so they could be aware of it. It is not giving the neighbors the possibility of accepting or denying that this is going to happen. It's simply making sure that they do get notified. And the proof of notification would be either a letter that the neighbors sign or a piece of registered mail that indicates that the letter actually did get delivered. Third is creating a grace period for renewal for properties that have had no complaints. If they miss their renewal period, then they would have a 30-day grace period to catch up and get that rather than lose there. And again, that was a request from the short-term rental owners themselves. Fourth is we had previously stated that there would be 1 permit allowed per lot for single-family and 2-family homes. This extends it to triplexes and quadplexes. Again, just trying to make sure that there's not too much of an impact in single-family residential neighborhoods. Those are sometimes sprinkled with legally non-conforming triplexes and quadplexes, and to allow 4 separate short-term rentals to operate in a quadplex with the possibility of each of those having up to 12 would be a lot of people. And I don't think that's what anybody intends for this to do. And then fifth is asking codes or requiring codes to send a letter, just a courtesy letter, if you will, notifying a property owner that there has been a complaint lodged. As it currently stands, codes doesn't send the letter until the 3rd complaint is sent, and at that point, the owner's at risk of having their permit revoked. So this gives, an owner, it may or may not be a legitimate complaint, but it at least gives the owner an opportunity to be aware that the neighbors have perception of a problem, so maybe they can fix it, which would be a win for everybody. And then finally, it changes the wording. We currently have a requirement that after 3 documented violations of the requirements, and by documented I mean that a Metro policeman showed up and wrote a report that said, yes, there was noise, or Metro Public Works showed up and said, yes, the trash cans are out on the wrong day and have been as they're not supposed to be, or that documented evidence from a website advertising for more people than are allowed by the code would also be considered a type of documented evidence. So it would have to be 3 verified documented types of complaints. Under those circumstances, the language has now changed from the zoning administrator may revoke the permit to the zoning administrator shall. Currently, it has become a somewhat long and drawn out and onerous process that's very burdensome on the neighbors that ends up going to environmental court a lot of times to revoke a permit for a property that has repeatedly offended the violations. So those are kind of the 9 things that it does. I think for the most part, those are issues that I don't think will be changed by the consultant's report. So I would like to go ahead and get this one moved forward. I think there's some things like the grace period and the permit expiring that are just housekeeping that we need to do. I'd love discussion on the individual pieces just to see if maybe we need to move part of it forward and not the rest of it. But I would request moving the whole thing forward. Thank you for that time to explanation.
Thank you. Councilman Mendez, as a sponsor, would you like to speak?
I think Council Lady Allen hit all the points.
Okay, I thought I saw your button on. Thank you. Okay. Councilman Davis.
Thank you, Mr. President, and thank you, Madam President. I have a couple of questions for the sponsor. For both of them, whoever can answer them, it's fine. The first one is, I want to thank you for your hard work on this end, and I understand we need some regulation, but I have a couple of questions when it comes to, the quad and the tri will those residents get notice before, because right now a quadplex and a triplex can get as many permits as they want. Is that correct?
May I speak?
Yes.
It's a little fuzzy right now. If you interpret those as, quote, multifamily as opposed to quadplex, and I'm not sure really where those fall into the category, then under multifamily, there is currently no cap for non-owner occupied, and it's not specifically stated in the one permit per lot restriction. So it probably could be interpreted to say, yes, they could. If someone has already gotten multiple permits on that lot, they are grandfathered in, and that's consistent throughout any changes that we make. So, and we will be sending out summaries of all the changes that are made to both the major platforms, as well as making sure the information is on the Metro Code's website.
Thank you. Councilman Davis, would you like for the zoning, Mr. Herbert, to answer your question?
If you like, yes.
We classify anything that has 3 units or more as multifamily. So actually, we're in favor of this because it cleans up, like Council Lady Allen said, it cleans up a bit of an ambiguity where you've got a triplex or a quadplex. Heretofore, we've had to classify that as multifamily, which leaves unlimited permits. So we're in favor of this.
All right.
Sir.
And my follow-up question, I admire Councilman Mendez and Council Lady Berkeley for deferring the first couple amendments till the consultant gets done. Even though I can understand from one aspect how this should go forward, but with everything going on with the consultant, I'm kind of wondering, can this portion wait also? Because I was looking over the numbers of the revenue that we're getting from the Airbnbs, and it's significant. I don't know if everyone has had a chance to look at the numbers. We could do a lot of good with that revenue. And also, I know that, and forgive me, I'm Councilman Elrod if I speak out of turn. I know Councilman Elrod and I think another council person is also talking or looking at possibly getting a separate commission to govern the Airbnb, to kind of take the pressure off the BZA board. I mean, I've been to the BZA board the last maybe a couple of meetings ago, and it's starting to look like the planning commission, which is, we're killing that docket right now. And I don't want to overburden them, and I don't know. There's a few ways I feel that, I'm not suggesting that that my colleague defer this. I know she's worked her tail off, and so has Councilman Mendez, but I'm kind of very interested in what the consultant will say, and whoever's leading from the mayor's office, I'd love to talk to that consultant, because I understand they're talking to council people, so I would wonder where I am in that queue to talking to that consultant, because I have particular Airbnb issues that may not be happening or may not be addressed that, I want to put forward with the consultant to study, and especially how it's helping a lot of my citizens pay their bills. But more importantly, I was wondering if there's a chance that the sponsor, have they considered deferring it or not? Because I think right now with the revenue that we're getting, I don't want to damage, because we don't know what's going to happen in 5 years or 3 years.
Right.
Are we ever have a chance to get this revenue back again? Right. Okay. I know that's kind of long-winded. I apologize, Chair, but the numbers look really good, and they're only getting better.
Okay. Well, your point is well taken, and we'll give the sponsor an opportunity. Councilman Schumer. Oh, okay. Now you know I'm not that good.
Thank you, Mr. Chairman, Madam Chair. So I listened to the explanations that the council lady gave about what this bill is doing. I knew there were 2 bills. This one sounds like it's just basically getting the technical stuff right to make sure just things that needed to be accomplished anyway. And so I guess I'd just like to check. That's what it sounds like. Anything in here that was really, it doesn't sound like there's that much that's controversial. It just sounds like it's trying to fix the bill. So I guess this would be a question for the sponsor.
Councilwoman Allen.
Thank you. I would say there are 9 items, and 7 of them are truly boring, and 2 of them have generated some conversation with short-term rental owners. I mean, when I pointed out to them that I was adding a grace period, they appreciated that one. I have gotten one response from at least one owner who said, oh, if that's what it does, then I think that's great. So, you know, I've gotten mixed reviews on that. The 2 things that people would perhaps like further conversation on is the zoning administrator shall revoke the permit and the, hold on, 2 identifications. Oh, I left that one out. 2 identifications being required to prove that you were an owner-occupied property. We've had problems in the past with it being really easy to change your driver's license and come back and show that you live somewhere other than where it showed you lived a day before. So we just, have changed that to 2, and we've given a number of options to choose from. So I don't feel that that's onerous. That's something that is up for discussion.
All right, well, having 2 pieces of identification for owner-occupied doesn't seem to be that, understand, it's just making sure that they are who they are, say they are, and they are where they're supposed to be in terms of where they live. The first thing that you mentioned, that's the 3 strikes. Is that what that does?
Yes.
Okay.
3
so
documented strikes.
Three documented strikes, and then the codes administrator then has the ability to take action, or has to take action, right? So is that basically what it does?
That's what it does. And I'd like for Mr. Herbert to address that. I mean, if he can speak to if that language empowers him or is just semantics, and it would be helpful to know that.
Thank you, Council Lady. My only concern with the use of the word shall is, what if we had, say, a property standards complaint of just maybe paint chipping off of a gutter, and then another complaint within the same year of high grass, complaints unrelated to the use as a short-term rental. Under the current language, it would, if there were complaints under any other law or ordinance, it would compel me to have to then revoke the short-term rental permit. I don't know if that's the intent, but if we could, having a little bit of discretion regarding the type of complaint and using the word may as opposed to shall. That way I could take a look at it, see the substance of the complaints that we've gotten. If they were related to the short-term rental, then revoke. So that's just my thought. Thanks.
Thank you, Mr. Herbert. And the chair was going to address that issue of shall, but we'll go to Councilwoman Van Rees.
Yes, thank you very much. And
Wait, hold on.
oh, I thought,
Councilman Shulman, what
I was just going to say thank you.
No, seriously.
welcome, Jim.
Are you through?
Well, so obviously it sounds like that needs to be addressed. So if the chair is going to address it, I'd be interested in kind of how people feel about that one.
Okay, yeah, I was going to address
Yeah, because the shall to a may, it almost sounds as if the zoning administrator is saying, what if it doesn't have anything to do with the idea that it's a short-term rental property? Okay. Okay. All right, thank you.
Thank you, sir. Councilwoman Chairwoman Van Rees.
Thank you. Yes, in continuing that thought, I wanted to find out about the word may and shall for those very reasons. So thank you for bringing that up. It concerns me, but also in regard to just the documented evidence, the ambiguity of what that might be, it concerns me a little bit just because of the hearsay that might happen in regard to that. So I think that in itself concerns me a bit. So I would love to hear a legal opinion in regard to the use of quote-unquote documented evidence. And then the verified, I guess I should say verified documented evidence. Because of environmental court, nobody enjoys that process, but it is a process, it's a due process, and yes, it could be faster somehow. We need to do that, but I'm concerned that this is not helping ensure due process, and so that concerns me. The other thing that I wanted to mention, and we can pop back to the documented evidence, but the 60 days to that I'm not sure if that's enough time because of so much that has to be done for getting a place ready. So I just wanted to kind of hear what the current timeline is if someone needs to get their fire and everything checked out, is that enough time? And if our departments are slow, I don't want to make that a problem for the applicant just because we're slow at doing it. So do you have some comments in regard to those things?
I'm going to defer to Councilman Mendez on the hearsay. He helped with that language.
All right, so in Section 9, and hopefully Metro Legal could confirm this, every single one of those phrases in there, public records or reports, records of regularly conducted activity, direct or online statement against a person's own interest, are straight out of the Tennessee Rules of Evidence, and any judge ought to have a complete body of law to describe what each of those things means. The idea, because of the concern about what's the standard being used, especially when it's hearsay, the Tennessee Rules of Evidence are set up that hearsay is admissible under certain circumstances where the information is deemed reasonably reliable. So the use of reasonably reliable information is cribbed out of the Tennessee Rules of Evidence, and that list is all word for known codified exceptions where hearsay is in fact allowed. So the idea behind this language is to make it so to lawyers and judges, the language in this section ought to have a very clear meaning with an existing body of case law saying what it means. And I think Metro Legal could probably confirm that.
Yes, I don't disagree with anything that has been said, and I think that may have been the reason it was written in that manner, so that it would give that kind of credence to the information that was going to be provided to Mr. Herbert. And just to add to that, this is really a higher standard that is being imposed right here, because typically you're not going to be under the rules of evidence for an administrative procedure such as the BZA is going to have. So this actually increases kind of the standard of that we would normally be looking at.
Thank you. Councilman Rosenberg.
Thank you, Mr. Chair and Chair Lady. I have the same concern as Chairwoman Van Rees with respect to the 60 days. The other piece is the 2 pieces of identification. There's a pretty short list on here: a driver's license or state ID, a voter registration card, which I couldn't find for my life, or a bank statement, which I would not be inclined to hand over to a government official. Is it the intent that there be additional forms of ID acceptable in here, or is this the way it was written? If one of the sponsors wouldn't mind answering, please.
Thank you. I'll answer both those questions. I'll start with the 60-day. That was a suggestion from the codes folks. Clint Harper has done 1 million of these, actually 3,000 at this point. And he, I mean, for the most part, people come in, and at this point, within 2 weeks, they've gotten the fire inspection. They may have to come back one more time and provide some piece of paper they didn't know that they need to have. But in general, it's a 2-week process at the longest. So they felt like the ones that had hung out there longer than 60 days had been, well more than the time that has been needed for almost all of those 3,000 to get their permits. Second question about the 2 pieces of ID. I think we would be open to other items on that list, but not to broaden it to the point that it's easy to be fraudulent about it, because that's the problem that we're having with a single piece of identification. Is it's not that hard to go change your driver's license and come back the next day with a different address on your driver's license. And so we wanted to make it to be types of identification that would be hard to do if you didn't actually live at that place. We tried to provide at least 4 so that it would be possible to get 2 of the 4. If there are other types of identification people can suggest, I would be happy to entertain those possibilities.
Thank you.
Thank you, Councilwoman. So would it not be fraud already to take your driver's license, go get a new address, and then apply again?
You're on.
I will defer to the lawyers on that. I'll start with Mr. Herbert.
It would be under Tennessee law to submit a state identification and then change that state identification for purposes of obtaining property using the same address.
Thank you.
Thank you, Councilman. Councilman Withers.
Thank you so much, Mr. Chair, for recognizing me. I know that I'm not on either, assigned to either one of these committees, but I appreciate the opportunity to ask a question. I, too, appreciate the comments from Councilmember Van Rees. It is really difficult to find a good balance, particularly in our quadrant of the county on this topic. So one of the things that I wanted to ask a little bit more about is the language that's in the bill with regard to the revocation of a permit from codes. I know there is a lot of frustration that's been expressed both by constituents who own or do not own short-term rental permits about enforcement and what they perceive to be lack of enforcement. So I wanted to know perhaps a little bit more about what that process looks like today for revocation of a permit. I am sensitive that neighbors often have a lot of complaints about a property and they feel like nothing's being done about it. I also want to be sensitive to our short-term rental owners who may have angry neighbors and to making sure that we're not, that we have a good process in place for due process for those folks to either A, have an opportunity to resolve those issues or B, to have an opportunity to be heard in some sort of a public forum about whether or not they have a right to retain their permit. So that's number one, is if I could hear a little bit more from Mr. Herbert perhaps about the current process for revoking permits and what his and maybe the legal department's view is about what that process should look like. And then also wanted to ask about what the current process in place looks like for determining that a type 1 owner does not actually live at the property. Thank you.
Thank you. Mr. Herbert?
Both processes to try to determine whether somebody actually lives at the property or to enforce for properties that have permits are quite frankly very labor intensive. So enforcement can come from perhaps they're advertising for too many bedrooms, perhaps they're advertising for more occupants than otherwise allowed under the permit. So we have to hunt down that advertisement in order to prove that. There's any number of websites out there that they could be advertising on. So we have to manually search all websites to try to determine if we can identify the property in question. Now, on the websites, they don't give you an address. So they just give you an area. So once we have an area, then we get on Google Earth. We use the assessor's website. We start trying to identify what the property looks like from the street using various methods and comparing it against what's listed on the advertisement website. Ultimately, the short answer is it's extremely time-consuming to do, and that's why, quite frankly, enforcement can be a little slow. Gaining the proof that we need to enforce is difficult. Once we have that proof, we have to give them 15 days to correct. We then have to do it all over again, check it to see if they've corrected it or not, and if not, we go to a warrant or we revoke the permit, depending on where we are. So that's really part of what the study that's been initiated is going to address.
Thank you. Okay. Council Lady Van Rees.
Yeah, I just have a quick question on that. You may or may not know, there might be some folks with short-term rental that would know. If you found out because of something on my listing for my site that I was saying that something was available that shouldn't be, and you've told me to change it, and I've got 2 weeks for that to be changed, is 2 weeks a reasonable amount of time for that website to be changed? I don't know, I don't have one. I don't know if you can go on and manually change it yourself or if it goes through a process depending on the server, you know what I mean? Because you may have made that change, but it might not be changed online.
I really don't know what the process is to change. We send a letter out giving somebody, putting them on notice, giving them 15 days to correct it, and then after 15 days we go back and recheck.
Okay.
So
Is there anybody here from one of the short-term rental folks that can tell us the average time that it takes? Mr. Hollins here. How long does it take if I change something on my listing? Is it pretty much an immediate change when I hit enter, or does it go through a process that takes?
Mr. Chairman,
Yeah.
Jamie Howland, Nashville Area Short-Term Rental Association. My client says 48 hours.
Okay. So 14 days is plenty. Just wanting to make sure. Thank you. Are there any more questions pending from the Conventions and Tourism Committee on this? Mr. Swope is in queue. Get in queue.
Hold on, Council Lady. Hold on 1 second. I think I had one before you. I got up. Councilman Swopes.
On behalf of both committees, I respectfully call the question.
All right, the question call. All in favor of the question being called?
There's not a second on that.
Oh, there's a second? Second. All right, all in favor of the question call? Let it be known as aye.
Aye.
No.
Okay. So you got
I'd like to
3,
keep
4,
talking about this.
3, 4, and 1 against. Coach Committee call for the question.
I believe I have someone in queue from the Conventions and Tourism Committee that would like to speak. I am in line.
Okay, that's Council Lady Hurt.
Thank you, Mr. Chair. And my concern is I received quite a few emails from individuals who say that they are in compliance, they pay their taxes, they do everything correctly, and this has been a wonderful revenue generating option for them. I apologize that I had to speak with the mayor's office that I wasn't here, and it may have been covered. But can those people who are in violation, who have complaints against them, could they not be handled individually, and these regulations and stipulations that this ordinance or this bill puts on them, could that not apply, and you just penalize those people that have not been in compliant?
Council Lady Berkeley, would you like to address that issue?
Thank you. I would say that this ordinance doesn't affect those who are in compliance. It gives them a grace period if they forget to renew their permit. If they do not have any violations, there's nothing here that affects them. If they already have their permit, there's nothing here that affects them. This would put some new requirements on people who are getting a new permit, and it would have some slightly changes in the way complaints are handled. But for the people who are operating correctly, will continue to get their revenue, they'll continue to operate, and it doesn't affect them at all.
Then obviously something is not being understood. It's not clear in the ordinance, or something is missed, because all of these people are continuously emailing saying no, because they believe that it is going to affect them. So how can we make it clear to them that if they are in compliance and doing what they should, that this will not affect them?
I have answered every email and explained what this does, and the ones who have read the email have responded and said, thank you for the explanation.
I have like to.
Are you through, Council Lady Hurt? Okay. Who else in the queue?
Mr. Davis, I believe, is still in queue, and then I'd like to ask a question.
Okay. Councilman Davis?
I have some concerns about the bank statement, and I don't know if there's a way for us to, and it's probably too late because we can't really amend anything now, to get rid of the bank statement part, right now.
Okay, so you have a question with the ID, is that it?
Yeah, because I don't want to, because with the two forms of ID, driver's license, and I think the attorney's answer that is still a crime. If you falsely use your driver's license to to buy or get a property basically by changing your driver's license. But the bank statement, I have a concern about that.
Okay.
And I'd like the motion for this to be deferred, until we can get that cleared.
Councilmember Allen, if I understand correctly, there are two things from my committee that are still of concern. The redundancy of the IDs that, like they've already given testimony that they are who they are and where they live. And clearly the bank statement issue. And then the other is going back to this idea of changing from may to shall. If I'm correct, from my committee, those are the two main things that are coming up. Can those items be addressed at this point in this game? And if not, can you defer it so that they can be?
The going by the rules way to address those, which I'm willing to do, is to defer tonight on second reading so that it comes back on second reading, and that would give me 2 weeks to file a timely amendment, which I could put out in public for comment on that. And, I'm happy to work on additional types of ID, and I can work with Mr. Herbert on the issue with the property standards complaints. I think is very valid.
I certainly think that that's reasonable, and I move that that you consider making that motion.
One meeting deferral.
Okay. There's a motion on the floor before the Tourism Codes Committee. One meeting deferral. All in favor?
Aye.
All opposed? Let the record indicate 1, 2, 3, 4 on codes.
And on conventions and tourism, all those in favor?
Aye.
And we have you down as recused. Any
All right.
opposed? All right, thank you.
Let the record indicate that
For one
Codes
meeting.
Committee, Tourism Convention have deferred at the request of the sponsor for one meeting on Bill 2016-381. Okay, next on the agenda is Bill number 2016-382, sponsors Mendez. Code, the caption read, amends the Metro Code pertaining to types and quantities of short-term rental property. Is there a motion? Second. Chair second.
Sorry. I'm still writing down notes from the other one. The conventions and tourism, do I have a motion? Do I have a second? Scott?
Second. Okay, discussion, Councilman Mendez.
Thank you, chairs. For the same reason that I mentioned with 375, I would ask that the committees move to defer this one indefinitely so we can find out how the mayor's consultant process goes.
Second. On both committees?
On both committees?
Okay. All right.
Anyone from either committee opposed?
All right. Councilman Davis, you wanted to speak? Oh, okay. All right, let the record indicate we have an indefinite deferral by the request of the sponsor. Codes Committee voted 4-4, none against.
And I have 4 in favor, none against, 1 recusal. Thank you.
All right, that brings us to the last item on the agenda, 2016-417. It reads, amends the Metro Code to prohibit the display of vehicles for sale upon residential properties fronting arterial streets. Is there a motion? Second. All right, discussion. We have the sponsor here. Councilor Johnson, would you like to address the
Thank you, Chair Coleman. This is something that will strengthen our codes, standards in terms of vehicles that are placed for sale along major roadways on residential properties. So our legal intern, she did a tremendous amount of research on this issue, and there are other municipalities that are already have this legislation, And so we're just catching up here. So I would ask for your approval because I think this would improve the corridors from becoming property standards issues with people with vehicles for sale on their private property along the commercial corridors.
Thank you, Council Lady. Okay, any members from the code?
And there's a substitute.
There's a substitute, okay.
I believe planning and codes weighed in on that, Mr. Herbert, Bill Herbert.
Okay,
I think you all weighed in on
I do
that.
not have a substitute before me, and it's in the amendments packet. Okay, I didn't get one, so. Go on.
Thank you, Chair. The substitute substitutes the words abutting or adjacent instead of fronting on arterial street. Specifies that arterial streets are those that are designated in the major and collector street plan, and also changes the term principal purpose to simply purpose. That's the substitute changes.
Thank you. Any members of the committee would like to speak? If not, Council Lady Murphy. Sorry about that. Gotta have the right touch up here. Hey, there you go.
Thank you, Chair. I appreciate the opportunity to speak. And I know the councilwoman and I have spoken about this before, but I just wanted, because I did request a map of the properties in my district that this would affect, and I want to just kind of clarify. So if someone was selling their car, it would have to be in their driveway?
Yes, that's already part of the code.
Okay, and so what this does is it prevents like from parking in like your front grass?
Right.
Okay, and so will this apply if it is a street that is, so the car is parked on a street and you can see it from the road that it's not allowed to be on? Does that make sense? So for example, Christopher Street hits West End, the car is parked at the corner of West End and Christopher, would it apply to Christopher?
I'm not familiar with those streets. Are you familiar?
No, I'm
Attorney Jameson.
Attorney Jameson should be familiar.
I am familiar. What I would ask you to consider doing is to back up, and I would submit that it is arguably prohibited regardless of the street you're on because of other provisions within the code. Today, it is currently prohibited to post a sign onto the vehicle noting that it's for sale under Title 17. The property standards codes for exteriors of properties allow for the sale of motor vehicles, but it only addresses motor vehicles offered for sale on commercial properties. It makes no provision for sale on residential properties. Title 17 defines automobile sales used as a retail business, not a commercial or a private engagement. And the code otherwise refers to the sale of automobiles, used automobiles, as a commercial endeavor. If you are selling your car, not pasting a sign on it, and it is parked in your driveway, and it happens to have been advertised on Craigslist or something else other than a sign posted to the car, that is not the purpose for which it is parked on your driveway. So that's allowed. That's what we were trying to get at with the phrase principal purpose, but there was some concern by codes about the vagary of how that's applied in court. So arguably, this is adding a code provision to what is already prohibited by other provisions within the code, if that makes sense.
I think it takes care of the concerns that I have for my constituents, because I was actually surprised at how many properties I had that this would affect, and so hopefully if something strange does come of this, we can work together to figure out how to make that work.
Yes.
Thank you. Councilman Davis, did you have a question or your lights on from before? Okay, thank you. Okay, there are no more questions. Oh, I'm sorry, Dave. Didn't see you back there. Councilman Rosenberg.
Thank you, Mr. Chair. I'm sorry, Mr. Jameson, did you say that it's illegal now to put a for sale sign in your car in your driveway?
Yes, sir. Putting a sign in a residential property for the purposes of selling an automobile is strictly prohibited under 1732-050Q.
Wow. Okay, thank you.
Okay, any more questions? Okay, we'll be voting on the bill, then we'll vote on the bill as substituted. All in favor of the bill, let it be known as aye. All opposed, let the record indicate 4-4 voting on the bill. Now we're voting on the bill as substituted. All in favor of the bill, let it be known as aye. All opposed, let the record indicate 4-4, none against, and recommend approval from council.
Thank you, Chair Coleman and the committee.
Thank you. All right, members of the committee, that's all the business we have today. I would like to say one other issue that came up to the Codes Committee. Someone asked from the community that we define the term of mulch, and I've asked council, General Counsel to put a definition together for us, and he has it circulating. This is something that the neighbors have come to the Codes Committee and want us to take a look at. So I hope you get an opportunity to read that short bill, and if you can support it or if you have any questions, let me know. It simply defined what is defined as mulch. Supposedly it was awkward and it had some ambiguity in it, so we tried to define it so that the Codes Committee have a good body of information to work off whenever they cite one of our constituents. So please look at the bill, and if you have any questions with it, let Mike Jameson know or let me know, and we'll do what we can, but we intend to introduce it the next time around. There are no more business. That's it for the Codes meeting, unless we have any committee members that would like to speak. Is that it? Okay. Codes Committee is adjourned. Thank you.